Would please make their way to a seat. We will go ahead and get started this morning. I appreciate everybody being here on a Monday morning, and we'll go ahead and call this public meeting to order to hear comment on House Bill 3270 to amend the deliberate intent statute to limit non-economic damages to $250,000 to order. Just a couple brief items before we get started. Number one being a thank you for everybody for being here, for your time. Number two, we hope that everybody will recognize that we are operating under the House rules of decorum, and we just ask that you show all of the speakers the same respect that you would want them to show you. And these generally go smoothly if we can abide by those very simple guidelines. This morning, we have speakers to speak in favor and opposed. We're going to provide every speaker with 2 minutes to address the group. And then what you will see on the podium up here is a red light. When that red light comes on, we would ask you to please wrap up your remarks. And then if you don't, we may have some further encouragement to do so. But nevertheless, I will call the name of the first presenter and then the name of the individual that is to follow so we can keep moving here this morning. So the first presenter this morning is Chad Francis, followed by Dave Duffield.
Good morning, ladies and gentlemen. My name is Chad Francis. I'm a UMWA representative, a third-generation coal miner. I worked 15 years at McElroy Mine, 10 years underground and 5 on the surface. Just about everyone in this building says they love our West Virginia coal miners, but House Bill 3270, if passed, would make a company that knowingly puts one of our West Virginia miners in danger considerably less liable by putting a cap of $250,000 on a miner's life. That is not much when a widow may have a few children and a mortgage to deal with after losing the breadwinner of their home. $250,000 is too small of a price for a company that in court has been proven to deliberately kill a West Virginia coal miner. Also, another major issue with this bill, it would strip the rights of a miner who has had their lungs destroyed by an employer who fraudulently manipulated dust samples or concealed lung hazards from employees. Just last year, Black Diamond Coal pled guilty to willfully violating a mandatory federal health and safety standard and one charge of making false statements about dust samples. Please don't protect bad operators. These laws were put in place to keep operators honest and to protect workers in this state of West Virginia who toil in the West Virginia mines. Miners throughout this state are hopeful our legislators will keep these protections in place. The folks that carry their bucket to work for a living, the folks that sign the back of the paychecks are urging a no vote. Thank you for your time, Mr. Chairman.
Thank you, Mr. Francis. Dave Duffield, jointly with Melissa May, are next. And then followed by them, it will be John Kreitz II.
I'm going to rush through this. I'm Dave Duffield, managing partner of Duffield, Lovejoy & Boggs in Huntington, West Virginia. My former partner, Chad Lovejoy, a member of this body for the last couple of terms, we represented Miss Melissa May in a horrid accident in employment. She, a single mother, worked at a plant in my hometown of Spencer. She was employed there by a Canadian company that many years later even left. She was working on a machine with an open lathe that had been ordered by OSHA to be closed. That company had 134 injuries and $200,000 in fines in their first 2 years. Not enough persuasion to stop the injuries. As she bent over near this lathe, her long brown hair got wrapped in a 400 turning per second, per minute rather, lathe, sucked her hair in. As her friends frantically hit the safety switches, both of them, they had been disconnected, however, by the company that wanted to save some money because a fire had early occurred in under one of the machines. As it slowly sucked the top of her head off, her ears, her scalp, her friends screaming, she was then rushed to Roane General Hospital, then to Charleston, and then on to Kentucky, where she suffered 16 different surgeries, medically induced coma, pneumonia, stomach tube, tracheostomy, and in summary, was in trouble the rest of her life. She had cadaver parts put on as they tried to attach her ears and replace the scalp. That didn't work. They had to be removed, and skin taken over all parts of her body, leaving scars that never will be erased. The mental injuries, depression, anxiety, post-traumatic stress, and the worst, as Dr. Bobby Miller testified, headaches, migraines, the worst you've ever had, times 10 every day, affecting her life with her child a year or two before she could even take a shower with a Xanax. She will tell you what happened after with drugs.
Thank you.
Okay. I had went to work and I got hurt, woke up 3 weeks later. My whole life had changed. I had got addicted to opioids, and I had to, I was the first graduate from Family Treatment Court in Roane County. So it's been a long road for that. It wouldn't have been for this law, I would be living on welfare. Lord knows what things would have been like. So please don't change this.
When that company left, all of you would have paid higher taxes. Small business, individuals, paying for a company that wasn't even from this country. Shifting the life of nothingness even further to people like this. I don't do as much work anymore in deliberate intent. I came here because of these clients. The future of Melissa Mays, if you do what they ask you to do.
Thank you. Thank you for sharing. John Kreitz, the second, followed by Robert Hyde.
Hello, I'm John Kreitz II. I'm president of Allegheny Wood Products, and I'm here in support of House Bill 3270. We've just heard a very tragic story. Last year when we debated this issue, we heard several sad and tragic stories then as well. And I think I speak for almost all the manufacturers in West Virginia that there's nothing that we hate more or think is more tragic than a serious accident in the workplace. I think, however, today we're talking about two different things. The deliberate intent statute, the way that it was, the spirit of what it was originally intended to be, I don't think manufacturers in West Virginia have a problem with it. If a manufacturer or an employer willfully injures someone through the way they direct them to do their work, I don't think there's any issue with leaving it on there to sue them. And House Bill 3270 does that. The problem with the way this is litigated now is there's so many false claims. Anyone with a serious injury can bring a claim, and it causes a huge burden in insurance, litigation, and it's a huge risk for any employer in West Virginia. House Bill 3270 fixes all that. It should eliminate or mostly eliminate all the false claims that are brought, and also ensures that any victim of an accident gets the majority or a bigger percentage of any reward that is gotten. And my father started our company 50 years ago this year, and he was always offended by companies that would stay just across the West Virginia line. In Virginia, Maryland, Pennsylvania, and we do some business in those states. But one of the main reasons that they stay there is that they have a competitive advantage over being in that other state than West Virginia. I do business in these other states, and there's no issue like deliberate intent ever comes aboard. It's all handled by workers' comp. You don't have to carry any insurance or anything to cover it, which is a huge competitive advantage because insurance is extremely expensive if you can get it at all. So please support House Bill 3270, and let's fix deliberate intent once and for all. Thank you.
Thank you, Mr. Kreitz. Robert Hyde, followed by Bill Robinson.
Hi, my name is Robert Hyde. I'm a husband and a father, and I'm here today in opposition of House Bill 3270. I was injured 9 years ago due to my employer violating industry safety standards. The result was the amputation of my left leg below the knee. Having the ability to hold my employer accountable for the financial and psychological impacts of my injury helped me and my family to move forward with our lives. Every morning I have to put my prosthetic on, every night I have to take it off. It's a constant reminder of what happened to me. My injury has and will continue to impact myself and my family's lives in many ways. My wife still has trouble talking about my injury. I have a 2-year-old daughter. Sometimes I wonder how I'll be able to play sports and keep up with her as she continues to grow. I have to continually learn how to adapt to complete normal activities without hurting myself or damaging my prosthetic. There's no amount of money worth going through what me and my family has been through, but telling me my leg is only worth $250,000 is disheartening. Putting a cap on the amount of money that will have a direct impact on making injured people's lives a little easier is only going to benefit employers' profits and not provide any accountability for a dangerous workplace. These are only a few implications as a result of me being injured at work. I hope you take into account the proceeds from these lawsuits can help injured West Virginia families maintain their finances and dignity.
Thank you very much. Bill Robinson Jr., followed by Kelly Ellswick Hall.
Good to be here today. My name's Bill Robinson Jr. I'm owner of Robinson Logging Company, LLC. My son, 2 sons, my wife, we started this company in 1993. And since we only have 2 minutes, I'm going to tell you a story about when and I'm also chairman of the West Virginia Loggers Council. When I took that job about 7 or 8 years ago, one of the first things we tried to do was we contacted a firm in Louisiana to look into workers' comp here. We got a hold of this guy, he needed some premiums, so we got him 74, sent them to him. They done an analysis on him, contacted us back and said that we were paying around 1/3 to 1/2 too much. He contacted 3 major carriers in the United States that wrote workers' comp for logging. They looked at his analysis. Every one of them agreed that there was money to be made here. And when he asked the question to each one of them separately, he was told, no, we're not interested in going to West Virginia. We consider them to be a suing state. As a resident, as a business owner, and as a leader of an industry, this really hurt. It hurt to find out that that's the way people looks at us. We can change that starting here today. 2 years ago, I sat in a conference, Coeur d'Alene, Idaho, and I watched this lady present this issue from Louisiana to where the lawsuits got so bad that the insurance company started leaving Louisiana. They had to make major changes right quick. I talked to her again this past fall in Missouri when I was at the annual meetings for the American Loggers Council. She told me they're starting to trickle back slowly. And that's what's going to happen to us in this great state if we don't start straightening this out. Thank you, sir.
Thank you, Mr. Robinson. Kelly Ellswick Hall, followed by Caitlin Mora.
Thank you, Mr. Chairman. This bill results in a giveaway to badly behaving companies who least deserve it and do the most harm. I'm Kelly Ellswick Hall from the Masters Law Firm, and I've been representing injured workers in workers' compensation and deliberate intent claims for coming up on 29 years. And you know, the rights of injured workers, particularly in West Virginia, to adequate compensation have been chipped away over the past 20 years or so to nearly nothing, almost crumbs. It's so hard to get a permanent total disability award in West Virginia, there may have been less than a handful granted last year. The most seriously injured workers suffer the most under our workers' compensation benefit scheme, which is different than Virginia's. And make no mistake, the rights of injured workers are the rights of all workers. They're your rights, they're the rights of your father, your sons, and your daughters. And now this bill wants to take yet another bite of your rights and give your rights to companies guilty of the very worst misconduct. And they do this by making sure that if your employer is caught, they only have to pay you and your family at most $250,000 for your pain and suffering, even if they kill you. $250,000 measly dollars in pain and suffering to a father and mother who lose their only son, crushed by a wall of rock in the mines because his employer intentionally ignored reports put in writing of crumbling and falling walls of rock for weeks, keeping production going at all costs, at the cost of that boy's life. $250,000 measly dollars in pain and suffering to the younger man who, because of the misconduct of his employer, suffers a massive head injury and bleeding on his brain in a rehabilitation hospital for more than 2 years and now lives his life in a retirement assisted living community because he needs assistance to live. And remember that limiting a right to where it is not meaningful, to where it costs more to do the case than you can recover, where it's limited to where an attorney can't afford to take your case, that's just a fancy way of taking that right away from you, and that's what this bill does.
Thank you.
Thank you.
Caitlin Pitlick-Mora, followed by Kelly Kreitz.
Good morning. Thank you, Mr. Chairman, for allowing me to be here today. As mentioned, my name is Caitlin Pitlack-Mora, and I am here today on behalf of the West Virginia Chamber of Commerce to give a few comments on House Bill 3270 dealing with deliberate intent. As way of background, the West Virginia Chamber of Commerce represents businesses in all 55 counties. Our member companies represent over half of the workforce in West Virginia. As such, many of our members are interested in the ramifications of House Bill 3270. Reforming deliberate intent is an issue that the Chamber has researched and followed closely over the years. With that being said, the Chamber has reviewed the current bill, has discussed the bill with many of its members, and the Chamber is pleased with the bill's cap on non-economic damages and the reform that House Bill 3270 seeks to achieve. Thank you for your time and for allowing me to be here today.
Thank you. Kelly Kreitz, followed by Shelley Rosser.
Good morning, Mr. Chairman, members of the committee. My name is Kelly Kreitz, and I'm General Counsel for Allegheny Wood Products. And I'm in favor of House Bill 3270. Thank you for hearing my testimony today. The testimonies we've heard here are moving and heartbreaking. And this subject is difficult at best for anybody. And I realize this is a tough sell because I'm asking some of you delegates to legislate away part of your income. But I'm here to testify about what happens after the lawsuit under the current statute. So for your non-lawyers, when a lawsuit's filed, it goes into discovery, which is when each side figures out the facts of the case on either side. And one of the part of discovery is they get to ask the witnesses, their potential witnesses, questions under oath. And under our current law, and this is for you non-lawyers, you go to where the witness is, or generally go to where the witness is. And this found many abuses. There's one case where the witnesses were in Puerto Rico. We went to Puerto Rico. The injured worker's attorney had two attorneys come, which is not unheard of, but one showed up in a suit, the other's a swimsuit. He showed up with a swimsuit, flip-flops, and a t-shirt. He stayed 5 minutes for the first deposition and then left. We had depositions for 2 days. I went home. They stayed for a week. They went first class because coach wasn't good enough. They stayed at the Ritz because the Marriott wasn't up to their standards. And then we settled. So let's go to the settlement. And I can tell you that what the plaintiff's attorneys received was quite substantially more than what the injured worker received. That is wrong. That offends me greatly. And West Virginia deserves better. West Virginia workers deserve better. They deserve to have more, to get paid more for their injury than their attorney does. West Virginia businesses deserve better. They shouldn't have to face bankruptcy on every case that's filed against them because they can't afford the insurance premiums. I urge you to pass this bill because we deserve better than what we have now.
Thank you, Mr. Kreitz. Shelley Rosser, followed by Danielle Waltz.
Good morning. I'm Shelley Rosser. I'm from Logan County. My husband was Lou Rosser. He was a proud coal miner. And back in 2013, there was an accident at the mines that my husband worked at. The man was injured and paralyzed from the neck down. The company was supposed to fix that spot by putting some reflective tape, some lights, simple fix. The company didn't do it. 3 years later, my husband, trying to exit the mine, hits his head, and my kids no longer have a father. I lost my husband of 20 years. Despite knowing the hazard, it's just something simple as that. And then you want to say that the company shouldn't be liable of something that they're responsible for? $250,000 to take care of 5 of us. One that's in college, the 3 teenagers at home. Now their life is constantly torn apart. My daughter is reminded daily. She cries on a daily basis. Therapy, medications, depression. We all suffer from PTSD. Remind you how live in Logan County, the heart of coal country, to see coal on someone's face is frightening to me now, and I see it every day. Thank you.
Thank you. Thank you for sharing. Danielle Waltz, followed by Rebecca Campbell.
Thank you, Mr. Chairman. My name is Danielle Waltz, and I'm a member at Jackson Kelly Law Firm, and I'm here to speak on behalf of the United States Chamber of Commerce Institute for Legal Reform in favor of House Bill 3270. I echo the sentiments and policy arguments made by the West Virginia Chamber of Commerce. Additionally, as this legislature is aware, workers' compensation is a system set up to hold employers strictly liable for workplace injuries of their employees. In return, the employees are barred from bringing tort claims against their employers. Deliberate intent statutes, like the one being discussed here, carve out exceptions for bringing common law tort claims against employers. Under this statute, employers can be sued, but it has to be shown that the employer acted with deliberate intention. States around the country have had a variety of ways of addressing this issue, some like neighboring Virginia not recognizing the cause of action at all. Over the course of the last several years, beginning in 2015, changes have been made to this statute, attempting to strike the appropriate balance between recognizing the workers' compensation bargain, but also allowing employees to pursue appropriate remedies in case of an intentional action. Last year, the legislature contemplated eliminating the cause of action in its entirety. House Bill 3270 strikes an appropriate balance, recognizing the workers' compensation bargain. House Bill 3270 allows the employee to recover, but limits the potential non-economic remedies and fees, as this legislature has deemed fit in other statutory circumstances. Therefore, we ask that you support House Bill 3270. Thank you.
Rebecca Campbell, followed by Phyllis Cole.
Good morning. My name is Becky Campbell. I am the widow of Matthew Campbell and the mother of our 3 boys. Matt was the love of my life since high school, and we went on to get married shortly thereafter. He was hurt May 2nd, 2018, and then laid in the hospital for 12 days after that, where he finally succumbed to his injuries. The incident at work was of the knowing and intentional actions of his employer as they were trying to move a 20,000-pound load illegally and unsafely that ended up pinning him to a railing and crushing him. My boys and I have lived a very long 4.5 years without him, grieving, going to counseling. A couple of us are medicated. My boys' personalities have drastically changed because they no longer have a father. My oldest son intends to go on to be a welder just like his dad. And that leaves me with the worry that if something like this happens to him, who's to take care of his family? Not only am I left to raise these 3 boys by myself, if it weren't for the settlement that we have gotten from his lawsuit, we would not have been able to buy our forever home that we are now in. The lawsuit took almost 4.5 years, and we have literally just moved and gotten settled. That is a long time for 3 young children who were 5, 6, and 9 years old to have an unsettling life. I urge you, please vote no against House Bill 3270 to make these companies held accountable, and if for anything, to make them follow the safety practices so this doesn't happen to another family, and they don't have to go through this even to be argued. Thank you.
Thank you, Ms. Kim. Thank you for sharing. Phyllis Cole, followed by Nick Grimmett.
Mr. Chairman, Vice Chairman, and members of the House of Delegates, thank you for the opportunity to speak today. My name is Phyllis Cole. I'm representing Allegheny Wood Products, a West Virginia family-owned company that employs 865 people. I'm here today to ask for your support on House Bill 3270. This bill does 2 things. First, it helps our economy by helping employers keep and grow good-paying jobs right here in West Virginia. And 2, if someone is injured and brings a lawsuit, this bill ensures the injured worker gets more money in his own pocket, not their lawyers. A number of years ago, I served in this House of Delegates and later worked alongside Governor Underwood in his administration. So I know that public service isn't easy. But I also know that you're here for the right reasons, doing what's right for the people of West Virginia. So much progress has been made in the last few years by fixing problems of the past, and I thank you for that. We're finally on the right track. This bill addresses one issue that's still really holding our state back and desperately needs to be fixed. Passing House Bill 3270 is a step in the right direction. Many of the provisions in this bill are very similar to how you fixed our broken medical liability system and other areas of workers' compensation several years ago, and they've all worked. When you're hearing from the opponents today are some of the doom and gloom arguments they always make, but it never turns out that way. Instead, this bill does just the opposite. Employees are protected. In fact, the state's largest workers' compensation carrier in COVA has already said this bill will lower insurance rates across the state. I don't know exactly how much these attorneys charge, but I hear they take it up to 40 to 50% of the award. Give our workers what they deserve. More jobs, more money. Please pass House Bill 3270. Thank you.
Thank you, Mr. Cole. Nick Grimmett, followed by Brandy Grimmett.
My name is Nick Grimmett. I'm from Logan County. I've got 14 years of underground coal miner. I work for, I run a continuous miner. Guys, if this bill passes, I mean, it's just, you want to talk about the safety. If you've never been underground and actually been there and done what we've done, you don't realize what you're going to do once this bill passes. $250,000 wouldn't even cover a quarter of what I would trade it all right now to have what I had before. I mean, it's pitiful. I could go on for days, but the safety of the men and women that work is going to be drastically changed. For $250,000 a company, especially a coal company, that's hardly no money to them. I don't know if you've looked at what coal companies bring in monthly, yearly, but $250,000 is nothing to them. I mean, it's just, you have to be there and live it. Unless you've had a rock fall on you like I have, it's hard to say that my life is only worth $250,000. I mean, it's a disgrace to workers. Does something else need done? Maybe, but $250,000 is not nearly enough to even pay some of my bills off. Without my settlement, what would I do? Where would I be? Homeless? On the street? Who knows? But that's all I have.
Thank you, Mr. Grimmett. Brandy Grimmett, followed by Bill Dempsey.
My name is Brandy Grimmett. I'm Nick Grimmett's wife. We live in Logan County. In 2020, my husband was crushed by a rock that was 1,000 plus pounds. The company was warned the day before that the ribs weren't good. Nothing was done. The next day he goes to work and he gets covered up. $250,000 would not even cover 1% of his medical bills. My son has to go on without a dad to teach him how to play sports. $250,000 would leave us, we would be homeless. We would not have nowhere to live. Just don't pass this bill. My husband's life and the others is way more than $250,000. Thank you.
Thank you very much. Thank you both for sharing. Bill Dempsey, followed by Terrell Boggs.
Good morning, Mr. Chairman. Thank you for allowing me to speak this morning. I'm here representing Weyerhaeuser Corporation, and we are in support of House Bill 3270. Weyerhaeuser has two manufacturing facilities in West Virginia, one in Heaters and the other in Buchanan, along with managing about 253,000 acres, and we employ nearly 500 West Virginians. House Bill 3270 addresses the need for controlling costs and providing equity in damages. The workers' compensation program works when it strikes a balance between the rights and interests of employers and employees. This bill addresses some outstanding issues or longstanding issues for businesses, especially with timber harvesting and wood products manufacturing facilities. Again, thank you for allowing me to speak this morning.
Thank you very much. Tara Boggs, followed by, excuse me, Eric Carlson.
My name is Tara Boggs, and I'm here to read a statement on behalf of Jonathan and Bethany Barber. Jonathan and Bethany Barber wanted to be here to speak against the bill today. Unfortunately, Jonathan was hospitalized this week for COVID. His paralysis from the chest down has left him unable to cough, and it is hard for him to breathe without extreme difficulty. Bethany was exposed to and asked that someone read this statement on her behalf. Dear committee members, when Jonathan left for work that day in April of 2017, we had a good life. We'd been married a few years and had a 6-month-old son, Ledger. A few hours later, our lives were shattered. The coal company made a decision a few weeks before to mine 2 seams at once in order to increase production. However, they were doing this without the proper roof control plan and proper equipment. Mining with the equipment they had left loose overhanging rock at the edge of the roof, and the mine rib caught a brow. The previous shift employees pointed out to supervisors that a large overhanging brow needed to be removed because of the danger to the miners. Rather than stopping production to correct this known hazard, excuse me, the warning was ignored, and the boss said to let the night shift worry about it. Jonathan came to work less than 2 hours later. He was crushed and paralyzed from the chest down and confined at age 29 to a wheelchair for the rest of his life. I had to quit my job as a medical records specialist to be a full-time caregiver. This includes handling his urine and bowel care daily, which requires me to use my finger to stimulate him digitally so that he can have a bowel movement. This is what the rest of his life will be like. It is only because of this law that we can still afford our house, take care of our son, and get the lifelong medical care that Jonathan needs. Some of you believe that workers' comp helps, but workers' comp is useless. Jonathan had pressure sores on his feet and needed a $250 antibiotic cream. It was denied by workers' comp. While we waited for this cream to be approved, infection got into his bones, and Jonathan was forced to have his pinky toes amputated on both feet because workers' comp wouldn't give him the medicine his doctor said he needed. What's next? I challenge any one of you to trade places with us for one day, let alone a lifetime. Would you take just $250,000 for a lifetime of pain and suffering and disfigurement? A life where you can't teach your son how to play football or take him hunting? A life where you can never walk down the beach with your spouse, dance together at your son's wedding, or once again, have the intimate relationship you once had?
Thank you, Mrs. Boggs. Thank you. Eric Carlson, followed by Ronnie Williams.
Thank you. Excuse me. Thank you, Mr. Chairman, Mr. Vice Chairman. I'm Eric Carlson. I'm the Executive Director of the West Virginia Forestry Association. And I've been in the forestry business for nearly 50 years now, and I would say that many of the stories we've heard today are tragic. I've seen tragedy myself in the field. One of the challenges we have in West Virginia is that we have nearly 1,000 licensed logging operations here, where the average employer is less than 5 employees. These are small businesses, and this drives the entire industry. These folks that take their risk going out in the field, working hard. One of the challenges we have here is that the insurance is not affordable to protect themselves against this type of injury from the kind of cause of action, the deliberate intent. House Bill 3270 really provides that balance that it allows this to be an affordable type of risk management, while at the same time providing that the cause of action for deliberately, intentionally hurting people, not to be looked at the other way. We think it's important. Safety is critical in our industry. When you're dealing with the kind of materials we are in the fields, steep slopes, hard to work conditions, fog, rain, ice, those are things that really safety is absolutely important to every single person in the field, and we take it very seriously. We want to make sure our workers are protected, and should that inevitable accident happen, we need to have that kind of risk management to protect them. But it has to be affordable, and that's been the challenge for us. There are only one company actually insures 95% of the loggers in our state, and many of those loggers simply can't get the kind of insurance that they need to have to protect themselves against this. 3270 will provide that lower rates that will allow them to have an affordable opportunity to grow their business and manage their risks more appropriately. Thank you very much for your time.
Thank you, Mr. Carlson. Ronnie Williams, followed by Bill Tiana.
I'm Ronnie Williams. I was here last year and spoke against this bill. I don't know what I would have done without being able to take this cause of action. The $250,000 cap, that don't even cut it. If you figure it, 3 years ago, workers' comp said I would live 34 more years. That's $7,352 and change a year for me. That's it. And I know that don't cover anything. These two gentlemen, the phantom pain, I know he understands. It's not for me now, it's for the next person. Next person killed, injured, whatever. I urge you to vote against this bill. Thank you.
Thank you. Bill Tiano, followed by Bridget Lambert.
I was dancing with my client in the corner there. It took me a second. Thank you, Mr. Chairman. The violators want you to give them a pass. Last year we were here on this issue, and the issue was availability for the insurance in the timber industry. Mr. Carter and his group came up with a workable solution for that. And so now we're back this year, but with a workable solution. And so tell me what has changed. Safety is no accident.
Committee, be at ease for one moment. I'm sorry.
That's all right. I feel worse for him. You okay?
I think we're... Okay. All right.
Thank you. Safety is no accident. We teach our children right from wrong. Habitual violators do not know right from wrong. The issue is accountability and deterrence. If it becomes profitable to ignore the safety rules, companies will. And I'm not talking about these two fellas here. They have honorable intentions. It's the people that aren't here that scare me. The companies that work in the dark, that willfully violate the law. If you take away this right, those companies will flourish. Please vote against this bill. Thank you.
Thank you, Mr. Tiana. Bridget Lambert, followed by J.R. Carter.
Members of the committee, thank you for having us here today to talk about this. I am with the West Virginia Business and Industry Council, which is comprised of our state's primary business trade associations and many of our state's largest employers, representing thousands of jobs across West Virginia. Our organization works to advance pro-growth policies and common sense reforms that improve our economy and position us to capitalize on opportunities to come. BIG does support tort reform initiatives that bring our civil justice system in line with neighboring states and the rest of the country. We believe House Bill 3270 does that. Obtaining insurance for broad form liability has become nearly impossible. You've heard many testify today. Our forestry industry, our wood products companies are coming here to ask you and let you know that they're having a tremendous issue obtaining insurance to cover their workforce, West Virginia workers who need these jobs in our rural areas. House Bill 3270 addresses the need of state businesses while providing reasonable compensation for attorneys consistent with other statutes governing workers' compensation and medical malpractice in our state. By providing reasonable standards, House Bill 3270 should encourage insurers, and that's the intent, to lower premiums and foster competition in the state of West Virginia with more insurance availability. We encourage you to support this legislation and the industries that really are here asking you for this help. Thank you very much.
Thank you, Ms. Lambert. J.R. Carter.
Mr. Chairman, delegates, my name is J.R. Carter, and I am disheartened to have to be here again as the rights of working West Virginians are under attack again. But let me make very clear, this bill is not a compromise between workers and their rights and these special interests that are asking for you to give them a break. We've heard these stories from widows, from people who were scalped, from people confined to wheelchairs, called doom and gloom. This is not doom and gloom. This is their reality that they have to live with the rest of their lives because of the knowing and intentional decisions their employers made. So what are we here to talk about today? Changes that would occur after the employee has already proven the employer acted with deliberate intent. Are we serious? We want to give those people a break who knowingly and intentionally expose workers to illegal, unsafe conditions. That's what these changes are. We're talking about a $250,000 cap, which the way it's drafted, it says on each occurrence. So if another UBB happens, and that's 29 families affected by an occurrence, is that $8,620 each family would get for their pain and suffering? You have to understand how deliberate intent works to understand what's being said here. Deliberate intent is a cause of action that pays you above and beyond what workers' comp has paid. The employer gets a dollar-for-dollar credit and reduction for everything workers' comp has paid in the past or will pay in the future. All deliberate intent pays you is for your non-economic damages, because workers' comp pays nothing for your pain, suffering, scarring, disfigurement, and we want to talk about a $250,000 cap. Now keep in mind, in medical negligence cases, for injuries like this, that cap is $750,000 now. That's for a doctor who is accidentally committing something while he's trying to render life-saving aid, not a company that's trying to cut corners and increase profit at the expense of employees. If you pass this bill, a convict, a convicted child rapist in jail who gets attacked and then sues the jail authority, he would have more right to recover his non-economic damages than a worker knowingly and intentionally injured by their employer. This is sickening and disgusting, and the fact that an industry where only 35% of the timber industry that's here talking to you today will even buy workers' compensation coverage, they don't have to worry about buying deliberate intent. You can't buy deliberate intent if you won't buy workers' comp coverage, and 65%, 279 of 809 to be exact, is all that has workers' comp. I strongly encourage you to stand up for working West Virginians and vote no on this bill.
Thank you, Mr. Carter. That brings us to the end of the lists that I have before me. Are there any folks that have come in that would desire to speak for or against this piece of legislation? If not, if there are written materials that you had brought with you, I would encourage you to hand those to the clerk, who's sitting to my left, your right. We will ensure that those materials are disseminated to the members of the committee when it considers this piece of legislation. If there's no further business to come before the hearing, I will call it adjourned. Again, we appreciate everybody taking the time to be here today. Thank you.